So good morning and welcome to this February 5th meeting of the Maine Human Rights Commission. We'll call the meeting to order and begin in accordance with the agenda with the review of the agenda itself and the consent agenda. Do I hear any comments or additions?
Before we get started, our remote participation policy requires me to make sure that commissioners' votes can be both seen and heard. So I will be polling the commissioners who will need to signify their vote both orally and.
Okay. And I would entertain a motion regarding the adoption of the agenda as published and the consent agenda. So moved.
A second?
Second.
Hilarious. All right.
Good morning. Yeah.
I told.
Good morning.
All right, it's been moved and seconded. Any discussion? Seeing none, if you vote yes, you're in agreement. Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Douglas.
Yes.
Commissioner Walker.
Yes. And that takes us to the director's report.
Minutes.
Minutes. Oh, I'm sorry. Minutes are separate. Yes. You have before you the minutes of the January meeting. And I would hear a motion in that regard. I'll move adoption of the minutes. I've reviewed them. Second.
Moved and seconded. Any discussion? Seeing none, if you vote yes, you're in agreement. Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Douglas.
Yes.
Commissioner Walker.
Yes. And now the director's report.
Yes. So personnel memo, I have exciting news. Last week, we hired Carrie McCarter as an investigator. I actually don't know if any of you remember them. Carrie was a paralegal here for about 5 years. Left during the pandemic for about 2 and has rejoined us, and we could not be happier. And additionally, today is Michael Whitman's first day as Director of Operations. That's Mel's position. He would be here, but he is attending his new employee orientation at the Cross Building. If he gets done in time and we're still meeting, he'll probably join us for a few minutes, but I suspect, given the agenda today, will be done before he is. So that is very exciting. We did not get any candidates who would accept the position of business manager and were qualified. So we've reposted that and hope to have news on that one.
That's the new position.
That's the new position. Yeah. So it's sort of that person will be directly supervised by me and Michael, and they'll be doing the accounting, the sort of office day-to-day operations, all of that sort of stuff. So yay, after I think 3 months of telling you we were going to have updates, we have updates.
Do we still have an investigative position open?
Not at the moment. No.
Okay, I thought there were 2, no?
No,
There
this,
just
yeah,
one.
one investigator's position. I will have more news.
And operations and business manager.
Yes.
Made through.
You have a memo. Yes, a memo from Jane as to the status of cases in conciliation. 10 are in conciliation. Jane is working very hard on these. 5 have failed and 1 successful. So we have an agreement in E22-0031 Rudolph versus Eastern Maine Health Systems. And you also have a motion to dismiss H20-0085 Janelle versus Simmons, Dupere and Williams. This case, some of you may remember, has been around for a while. Reached a settlement with them after we filed the complaint in Superior Court, and they have done all of their compliance, and we are now finally done and can send that case to archives, assuming you approve both the agreement and Rudolph and this dismissal. So I need a motion for both of those.
Can I say so moved?
So right, to approve the agreement and the dismissal.
Yes,
Okay,
yes.
great.
I'll second.
Second, okay. So it's been moved and seconded. Any discussion? Seeing none, if you vote yes, you're in agreement. Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas,
Yes.
Commissioner Walker.
Yes.
Thank you. Very excited to get that box into a different place. All right, so next, investigation, you have little PDF case summary from me, and I apologize, I keep forgetting to change the date. This is not September 1 through 30th, 2023. This is in fact January 1 through 31, 2024. Make a note to change that next time. So in the last month, we've had 50 new charges. 28 cases have been either dismissed or withdrawn. The AD dismissal letter number is high this month because I had a stack of them, but I needed some confirmation from the EEOC that I could dismiss them and still get credit. So I was waiting for those. That's why there's a huge amount of them this year for this month. We had 8 cases that either settled or were settled through our mediation program or settled privately. And the total for January, $456,500 to complainants. It's a big number, especially compared to December, which I think was like 35. Any questions on any of those before I move into the quarterly reports? So I'll just run over the pending inventory. We have 645 pending charges with an average case age of 326 days, which is still pretty good for us. Less than a year old. It's impressive. Our investigators continue to work incredibly hard.
And that's 326 days average from the beginning of the case, and it's not necessarily to hearing, or it's to whatever the conclusion is.
Well, that's just where those cases are right now. So those, all the open cases that we have that haven't reached any conclusion, average case age is 326 days. Pretty good. We're really working through the backlog. I feel like we're finally in the last maybe 6 to 8 months coming out of the backlog that we had after the pandemic. Just like I said, the investigators have been working incredibly hard, as has the rest of the staff on this.
So is that number, I mean, it's been high like that since I've been here, but I came in during the pandemic. So is this substantially higher than before? Is this a backlog?
You know, I don't know. I could go back and look at Amy's quarterly reports, because it would be interesting to know sort of what that average is. Jeff had said something at the last quarterly meeting about that seems lower than it had been, that they're less than a year old, because we have 2 years to finish the investigation. So it's at least a good place to be. We've got plenty of time left on the cases that are open to get them wrapped up. It says that I'm going to give you the finance report. I do not have it from the budget office yet, which is probably my fault because I asked for it on Thursday. Usually they're pretty fast and can turn it around, but it's the legislative session, so things are busy right now. When I have it, I will be happy to email it to you and you all can see if you can make more sense out of it. Litigation, I'm going to ask that we take an executive session. Oh, and you have our quarterly training and education report. As a staff, we've either attended or presented at about 10 different events since from October 1st to December 31st. Any questions on any of those reports? And the last thing is new business. The legislative session, as I just said, is ongoing. We have a work session scheduled for Tuesday to discuss our amendment to the MHRA. That is one that just corrects the reference to the statute governing protective orders, because they repealed the section that was referenced in our law last session. So we've corrected that. We have made a tiny adjustment to the credit extension so that it says spouses instead of husband and wife. And we are moving Barbara to a major policy influencing position. She'll still be commission counsel, a different grade. That's the statutory position. We have currently, it's the executive director and a compliance officer. We haven't had a compliance officer for more than a decade.
Funny, with Jill, I'm sorry.
It was
just thinking about this a few minutes ago. He did Jill, or that.
I think the last time we
Jill
had one, it was
last
Jill. Yeah.
Yeah. So,
Yeah, so we haven't had somebody in that position, and most of what that position did is now done by Jane in monitoring the compliance agreements, so. And Barbara writes both all of our statutory amendments and also all of our rules, and if that's not policy influencing, well, what is? That's all I have right now. Is there any questions? None?
So we've got about 4 minutes until 45.
Great.
You're unmuted now.
Tom, Are you,
I'm with you. Here I am. Yep.
all right, I think we're ready to begin the meeting. Good morning, my name is Ed David. I'm the acting chair of the commission on behalf of my fellow commissioners. We welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced now. We have additional agendas, including the consent agenda, available in the back of the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time. The commission has voted on those cases and will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. Commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium or online to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one relevant factual errors, two relevant omissions from the report of facts submitted during the investigation, or three relevant issues and questions concerning interpretations of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that commissioners may ask questions. I will ask you to introduce yourself as you come to the podium or are called upon for the case. The first case this morning is Dustin White versus Liberty Mutual, and that is E22-0076. The recommendation is to find no reasonable grounds, therefore we'll hear from the complainant. Is that correct? All right.
And I'd just like to remind everybody who's presenting today that the names of third parties are confidential by our statute, so please do not reference anybody who is not named party in your case.
So is the complainant present? Dustin White?
Have the phone number.
I don't see Mr. White in the waiting room out here either.
Sure, yeah, Chelsea's gonna check. I see somebody with a phone number 207-416-2310. Is that you, Mr. White?
Kit, if I may, I did look up the phone number and it is not Mr. White.
Having called the complainant and having no response, the matter is still before the commission. The norm, well, we still need to have a motion, right? The normal situation is to, well, I guess it's not normal. We'll just see if there's a motion. Do I hear a motion in regards to the first case?
Commissioner O'Brien.
I would move that there are no reasonable grounds to believe that Liberty Mutual discriminated against Dustin White on the basis of age, and there are no reasonable grounds to believe that Liberty Mutual Insurance retaliated against Dustin White for engaging in Maine Human Rights Act and WPA protected conduct, and the complaint should be dismissed.
Second.
Okay, great. Any discussion? Seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien,
Yes,
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
The findings are no result for them. Attorney Haley, thank you for being here. We'll send a letter to the parties and council confirming the results of the hearing.
Thank you very much.
And I think to get back to the beginning of this case. Second case on the agenda is H 230328 A and B, Bobby Taylor versus Patricia Dearborn and TNS Property Management. It is a recommendation of no reasonable grounds, times 2 on both counts. No, it's the recommendation, and therefore we'll hear from the complainant.
Attorney Neal, you have 10 minutes. Would you like to reserve any of your time?
Yes, I'd like to reserve 4 minutes, please. Thank you.
Whenever you're ready, go ahead.
Okay. Good morning, commissioners. My name is Alice Neal. I'm here on behalf of Bobby Taylor, who is my client, and that is who is here by phone today. That is on the screen, just to clarify that for people. And we are asking the commission to find that reasonable grounds should be found for the disability-related claims and the retaliation claim. We're not contesting the no reasonable grounds recommendations for the sexual orientation and gender identity-based claims in the report. And so I'd like to just highlight a few things today. And one of the things to really keep in mind is that Bobby Taylor is an individual with multiple disabilities. Some of them are open and observable and obvious. She uses walking assistive devices. And Ms. Dearborn has known about Bobby's disabilities since before she even moved into the unit. And during the course of Bobby's tenancy, there are a variety of ways that Ms. Dearborn treated Bobby in a very paternalistic way, inserting her own judgment and viewpoints about what Bobby's needs were, what Bobby should be doing. And in large part, that appears to be based on Bobby's disabilities and what she believed as the perceptions, meaning she, Ms. Dearborn, the perceptions of Bobby's disabilities. One of the things that Ms. Dearborn did is that decided that if things were too difficult, and this was in talking with Bobby's case manager, that if conversation was too difficult, that she would communicate with the case manager directly, not with Bobby. Bobby was the tenant. Bobby never asked for a reasonable accommodation to have the communication go through her case manager. Bobby and Patricia Dearborn did have communication throughout her tenancy. However, if things seemed like it might be something that would be upsetting to Bobby, Patricia Dearborn made the decision that that communication should go to Bobby's case manager. And it is not uncommon for individuals to know that case managers work with people who have disabilities. Again, this is showing that Ms. Dearborn used a paternalistic viewpoint about her perception of Bobby, Bobby's needs, what Bobby could do, where Bobby could live, how Bobby could live, based on Bobby's disabilities. And Bobby's disabilities were such that she did ask for some reasonable accommodations when she lived there, and that was something that was not acted on. The reasonable accommodation that was asked for was a different unit, but the unit that Ms. Dearborn made available or said could make available was actually a unit that Ms. Dearborn knew was occupied, that Ms. Dearborn talked about that was occupied, and the report fails to note that the unit that Ms. Dearborn, that is the subject of the reasonable accommodation, was a unit that Ms. Dearborn knew had been occupied by many years for other tenants and still was through September of this year. I think it's important to note there are several phrases that Ms. Dearborn used throughout Bobby's tenancy when serving her with eviction notices or having conversations with her that are euphemisms for individuals with disabilities that, in my estimation, would equate to direct statements and discrimination that should be used to think about the entire case. And those are things referring to Bobby's needs and issues when she was served with a eviction notice in March, that she was also told that she had extreme medical conditions and medical health concerns in July whenever she was served with another eviction notice. And these are all ways to talk about Bobby and Bobby's medical needs, such that Ms. Dearborn even asked if Bobby was available to live in a place that was assisted living. And Bobby's needs do not rise to the level of assisted living, nor does she qualify for assisted living. but Ms. Dearborn believed that Bobby should be in assisted living or should qualify for assisted living. And so this is to give the mindset of the paternalism that was used when making decisions about Bobby and Bobby's disabilities and where she could live. And I think that something to specifically related to the retaliation claim that is not mentioned in the report is that Bobby first reported that she felt that she was being discriminated against to TNS management when they were doing work at the premises in February of 2022. It wasn't until February of 2023. It wasn't until March of 2023 that Bobby received her first eviction notice after she told TNS management that she felt that she was being discriminated against. And in that first eviction notice, Bobby was told that her needs and issues were reasons, not in the notice, but during the conversation with Ms. Dearborn, that her needs and issues were reasons that she needed to leave. And then very importantly, that in September of 2023, Ms. Dearborn, who had dismissed a case of eviction that had been pending in court, had no active case with court at that time. Bobby had at that time already filed a Maine Human Rights Commission complaint and another case in court that also discussed housing discrimination. And in mid-September, after Ms. Dearborn had notice of those filings and this direct case, Ms. Dearborn took steps to affirmatively file yet another eviction case against Bobby. And this is directly showing that there is a connection between Bobby filing a case of discrimination, wanting to be free from discrimination in her housing and to be able to live in her housing and enjoy her housing, and Ms. Dearborn instead, citing in her eviction notice, citing that one of the reasons, it doesn't need to be the only, but one of the reasons for the eviction was because Bobby had filed a case at the Maine Human Rights Commission. This would have a chilling effect on both
That's your 6 minutes, Attorney Neal.
Thank you, Bobby and other tenants in the future. I'll reserve the remainder of my time. Thank you.
All right. Question for Attorney Neal. See none. Attorney Neal, you'll have 4 minutes when we come back to you.
Attorney Newell.
Great. All right.
Good morning. I'd also like to ask to reserve 4 minutes of my time.
Sure. All right. Whenever you're ready, go ahead.
Thanks so much. My name is Sarah Newell. I'm an attorney at Eaton Peabody. I represent Patricia Dearborn in this case, as well as TNS Property Management. Although TNS Property Management doesn't exist and had very limited involvement in this case of only days. So this is a situation where the respondent has provided ample evidence that there was a non-discriminatory reason for both the eviction and for her conduct during the course of Miss Taylor's tenancy. Miss Taylor rented one of Miss Dearborn's apartments, and almost immediately after renting that apartment, there began to be issues with the sewage system in the apartment. And Miss Dearborn, at the time that the apartment was rented, had explained that because of this particular sewage pump, that it was very important to use non-biodegradable paper, that got lodged in the mechanism. It was very important to use biodegradable paper and biodegradable products. And so almost immediately, a couple months after Miss Taylor began to rent the apartment, they began to have problems with the sewage pump. They had multiple times where non-biodegradable paper was lodged in the pump and the discharge mechanism, causing backup of sewage into the apartment. That happened multiple times. Miss Dearborn was always extremely timely in her addressing of that issue and continuously addressed the issue in the apartment. But because of the number of times that this had occurred, damage was caused to the apartment that made it necessary for Miss Taylor to to remove the tenant from the apartment so that the apartment could be completely renovated. There was sewage, because of the sewage backup, it just wasn't a safe environment to live in. And so very early in October of 2022, Ms. Dearborn had conversations with Ms. Taylor about moving from that apartment so that the apartment could be renovated. Those conversations continued over a period of time. Eventually, Ms. Dearborn, those conversations were not successful. Ms. Dearborn offered to assist Ms. Taylor in finding different living situations. Those conversations were not successful. And so eventually Ms. Dearborn filed for eviction. Ms. Dearborn and Ms. Taylor's counsel, also from Pine Tree Legal, as Attorney Neal had conversations throughout, and Ms. Dearborn accommodated by withdrawing the eviction notice because Ms. Taylor had indicated she would leave the apartment freely. So it was not, as Attorney Neal has suggested, that the case was over and then a new eviction notice was refiled because Ms. Taylor filed a complaint with the Maine Human Rights Commission. Ms. Dearborn was always of the mind that Ms. Taylor had to leave the apartment. It was just represented to her by Pine Tree Legal that Ms. Taylor would freely leave the apartment. And so that's why that eviction notice was withdrawn. It became clear to Ms. Dearborn that that was not the case, that Ms. Taylor had no intention of leaving the apartment. And that is why she filed the eviction notice again. She did not indicate that the Maine Human Rights Commission, or she did not intend to indicate that the Maine Human Rights Commission case was one of the reasons for refiling the eviction. She indicated that was a clue to her that Miss Taylor had not ever intended to leave the apartment. There were plenty of evidence that was the case at the time. The investigator was satisfied that the reason that Ms. Dearborn gave, which was to refurbish the apartment, was the real reason. It wasn't pretext, and so non-discrimination. So the investigator has suggested that there were no reasonable grounds for discrimination. I'll quickly address the paternalistic part of this case as well, because as you know, the discrimination claimed is both that the eviction was filed discriminatorily and that Ms. Dearborn had acted in a paternalistic way towards Ms. Taylor. There was, although it was alleged during the fact finding and in the submissions that she acted in a paternalistic manner, there was never any evidence that Ms. Dearborn acted any differently towards Ms. Taylor than she acted towards any other individual and any of her numerous tenants. In fact, she is very accommodating to her tenants. She seeks to assist them frequently. And she did so with Ms. Taylor as well. There was no paternalistic motives there due to Ms. Taylor's disability. And there was never any evidence presented that was the case. Her failure to reasonably accommodate Ms. Taylor, which has been alleged, as the investigator found, Ms. Taylor, the only request for accommodation Ms. Taylor made was to live in a first floor unit, and there were no first floor units available during the time that she made those accommodations.
That's your 6 minutes, Attorney Noel.
All right, I'd like to take one more minute of that of that time. There's also the allegations that Ms. Dearborn referred to Ms. Taylor's needs and issues. There was never any evidence that Ms. Dearborn meant any disability related needs and issues. There were plenty of needs and issues that were related to the sewage pump and the habitability of that apartment, which is what she was referring to. And the allegation that she referred to extreme medical health issues, those comments took place during a call or a meeting between Ms. Dearborn and the case manager and Ms. Taylor on July 11th, and they followed Ms. Taylor indicating that she had extreme health and medical issues and shouldn't be evicted as a result of that. So I will reserve the remainder of my time.
Right, you'll have questions for Attorney Noel. Commissioner David.
Attorney Nolley, you said that there were multiple times that there was improper materials used that affected the pump adversely. Is that in the record? Because I didn't recall seeing that.
Yes, in our submissions, we've indicated the different dates that occurred, and we've indicated that JD Newcomb, who serviced the toilet, indicated that those materials were the reason for the pump malfunction. That's from our submission on November 27th, 2023, and included evidence of that.
And does the complainant resist that that allegation, I guess, from Ms. Dearborn, that you're not following the instructions to use biodegradable materials?
I think there was resistance from the complainant during the time. I think what the investigator found important and what we focused on was that there was no resistance from the complainant as to the fact that those issues occurred and that the damage to the apartment as a result occurred. There was no resistance to the fact that apartment needed refurbishing as a result. And honestly, Ms. Dearborn wasn't focused on blaming complainant for the issues, and Ms. Dearborn's reason for evicting complainant were not related at all to her thought that she did put biodegradable. It was really only that she needed to refurbish that apartment following those issues.
And your position is that after she made that first notice of eviction, the complainant said she would move and then dragged her feet on that, or what?
Yes. Yeah. There were conversations between complainant and her counsel and Ms. Dearborn that indicated that they may be able to move, and that was why the first eviction notice was withdrawn.
But there's no resistance or claim that the apartment doesn't need to be refurbished, that the damage is sufficient, that it needs to be dealt with without a tenant there.
That's correct.
Thank you.
Any other questions for Attorney Newell? Seeing none, you'll have 3 minutes when we come back to you. Sorry, I'm in the wrong side. Attorney Neal, you have 4 minutes.
Thank you. And Commissioner David, my client does deny that she used any inappropriate materials in the toilet or as part of the sewage system that was there. And that was something that was discussed during the investigation. And also my client did not believe that she needed to move to be able to have the renovation be able to take place. In fact, my client and Ms. Dearborn had conversations about some possibilities where Bobby would be able to stay in the unit potentially while the renovations were taking place. And to quickly clarify about the chain of events that happened in September is that my understanding is that there was an eviction pending, there was a case filed at the Maine Human Rights Commission and then also in court, and that during discussions that were between counsel and Ms. Dearborn at the time, there was a discussion there may be a unit that was available that was Unit 2 that was occupied that Bobby could potentially move to. And when that fell through, that was no longer a viable place potentially for Bobby to be able to live. And during that timeline is when when the eviction was filed again in September of 2023. And so my client does dispute about the sewage and about the ability for renovations to be able to happen. And I'd like to just quickly turn back to the fact that Attorney Newell does say that there's a legitimate non-discriminatory reason for the actions, for the evictions, and that is one part of the analysis. That's one part of the prong. My client asserts that there's pretext and that there were discriminatory reasons for that, and those were her disabilities, and that is something that that Ms. Dearborn knew and was aware of. And so, that is something that where Bobby's disabilities, if they still played a role in the decision for the eviction, still played a role in the decisions that Ms. Dearborn made, that is potentially pretext and is evidence of discrimination, even if there is a legitimate non-discriminatory business reason that is proffered for those actions. And And to get back to the needs and issues and the work that needed to be done, there were conversations that Ms. Dearborn had with Bobby that Bobby wasn't present when Ms. Dearborn had conversations with other tenants, but what Bobby did know is the conversations that Bobby had with Ms. Dearborn. Ms. Dearborn would mention that Bobby had needs and issues, that Bobby had already told TNS management she thought that she was being discriminated against in February, and then she was served with an eviction notice in March. And then as time went on, there were still conversations, no matter who brought up Bobby's disabilities or medical needs in July, that you have very extreme health concerns was said by Ms. Dearborn to Bobby in July, insinuating that Bobby should live in assisted living. Those are all indications in my mind that those are euphemisms for saying Bobby's disabilities, and that the renovations could take place with Bobby there, that there were issues related to the building. Bobby didn't contest that there were sewage issues. Bobby contested that there were inappropriate usage of the sewage and that the work couldn't be done while Bobby was there. And Bobby, I believe that this is a case that should be found that there are reasonable grounds, given the even chance standard that the commission has for both the discrimination claims based on disability and also for the retaliation claim, particularly because Ms. Dearborn does state in her eviction notice is one of the reasons for the eviction in mid-September is the Maine Human Rights Commission case that was filed by Bobby, despite the characterization that, that she was going to move out willingly on her own. They were having discussions about reasons why the eviction could have resolved in early September, but those fell through when there wasn't an accommodation that was actually able to be made.
That's your time.
Thank you.
Any questions for Attorney Neal? Yeah, Commissioner David.
Attorney Neal, it seems as though everybody agrees that the repairs need to be made, correct?
Correct.
And why aren't they done with her in place if she says she's willing to be there during the construction?
My understanding is that Ms. Dearborn decided that she couldn't do the repair work with Bobby there, despite discussions about the work potentially being able to be done while Bobby was there, but it would require removing a great number of Bobby's belongings from the unit to be able to make that happen. And Investigator Leva, if I am mischaracterizing anything that isn't in the record, I apologize, and please let me know. I don't want to say anything that isn't in the record. I do believe all of this is.
But complainant does agree to move and is looking to move to the other apartment, which it turns out is not available.
That's correct.
Isn't that correct?
That is correct.
And so I guess I'm asking, what are the discriminatory basis of saying that the work needs to be done and she needs to move out? If we all agree that it needs to be done for sanitary conditions or, whatever.
That is a legitimate business reason to give. However, Bobby still believes that there is pretext and that her disabilities are really the reason, because of the idea that Bobby needed to not be there, that Bobby's medical needs and issues made it such that she shouldn't be there in the premises. And the indication that the Maine Human Rights Commission case is a factor for the eviction in mid-September is something that on its own is something that they had been having conversations about, maybe moving to a different unit. Ms. Dearborn wasn't able to make that available. Ms. Dearborn decided to move on with another eviction. And she said in that eviction notice, one of the reasons I'm evicting you is because you filed a Maine Human Rights Commission case.
Thank you.
Any other questions for Attorney Neal?
Tom had a question.
Commissioner Douglas? You're muted.
Sorry, folks. I'm trying to decide if Commissioner David's question obviated my question. I guess what I want to know, just going back to the pretext, I think you just said that, basically with respect to keeping complainant in the unit while the renovations are going on, I think you just said that the owner, and correct me if I'm mistaken, but I think you said the owner expressed some reservation about being able to complete the renovations while the complainant was there. And I'm looking at the report page 2, and it says, I'm just going to read it. It says the second option was for owner to attempt renovations with complainant in residence, but this would require complainant to store the majority of her belongings in storage. Complainant told owner that this option was not feasible because she already had a full storage unit and could not afford to rent another one. Complainant added the eviction would leave her homeless because she was having difficulty finding alternative housing. And I'm just wondering, what's your position on all of that? I mean, are you disputing that these things are true?
My client couldn't afford another storage unit. She doesn't have the funds or she doesn't have the funds or the availability to have been able to put all of that into storage. She'd already expended money while she lived there. I'm going to keep it with what's in the record. My client does not dispute that it would not be feasible for her to, in the end, stay there while the work was done because she could not afford to remove the majority of her items. And that is something that we did discuss during the case, and Bobby said during the Issues and Resolutions Conference. However, the unit that Ms. Dearborn was offering was one that was still occupied by tenants as an alternative, as a place for her to live, and is a place to move to. And so it seemed disingenuous that Ms. Dearborn was actually making a space available for Bobby to move to if it was someplace that was occupied.
Right. Okay. And I don't want to argue with you, but again, there was the option for her to stay in the current unit while the renovations were going on. And it looks from the record and from your comments that your client sort of refused that option. True?
That is correct, based on financial means.
All right. Thank you.
Any other questions for Attorney Neal? Being none, we'll turn to Attorney Newell. You'll have 3 minutes.
Thank you. I think we've sort of been through it. I think it's pretty clear that Ms. Dearborn really felt that Ms. Taylor had to be out of the apartment in order for the renovations to occur. There was discussion about whether there was an alternative that could be successful there, which included the storage of materials. It also included offer of another apartment, which at the time Ms. Dearborn had been told that the tenants in that apartment were looking to move from that apartment, which is why she offered that. That in the end did not occur. So it wasn't a disingenuous offer, but it was, they were workshopping sort of what might work here. And although Attorney Neal has indicated that Ms. Taylor felt that the eviction was the result of her disability, there really was not any evidence that that was the case. And there was ample evidence that the unit needed to be vacated in order to be renovated. And over a period of time, that became more and more evident. So those were the reasons for the eviction. They were not pretextual. There was plenty of evidence that there was no pretext that should cause you to determine that there were reasonable grounds for discrimination. So we would ask that you adopt the investigator's decision that there were no reasonable grounds for discrimination on any part of this case. Thank you.
Any questions for Attorney Newell? Sure, David.
Attorney Newell, you offer her the other unit that's supposed to be coming available in October, it says in footnote 4. When is that offer made?
I'm going to have to go back through the timeline quickly to figure that out.
Well,
and I have my
is the position that complainant rejected the offer because it wasn't available then?
No, I believe they were discussing that offer and it became clear it wasn't available. I don't think complainant outright rejected that idea, but it just never came to fruition.
Yeah.
Any other questions for Commissioner Douglas?
Yeah. So Attorney Newell, good morning. I just want to make sure that I understand the efforts to keep complainant sort of on the premises or in properties owned by the owner. So with respect to keeping her in her unit, I'm just trying to make sure I get this. Do I understand that if the complainant had said, yes, great idea, and I'll put my stuff in storage and you can go ahead and do the renovations while I'm there, your client would have been okay with that and would have proceeded with the renovations, or no?
Yes,
They would have proceeded with the renovations.
they would have proceeded with the renovations with complainants' belongings in storage.
Okay. All right. Thank you.
And in addition, if that apartment had come available, or if another apartment had been available, it's clear from the record that respondent would have moved Ms. Dearborn to that. Ms. Taylor to that apartment.
Right. Okay. Thank you.
Any other questions for Attorney Newell? Okay, seeing none, thank you both. We've heard from both parties. Next, hear from Investigator Leva.
Morning, Commissioners. Can everybody hear me okay?
There's a bit of an echo.
It may just be this room. There's not a lot of furniture in here.
Okay.
Okay, sorry. So good morning, Commissioners. Again, as I said, the report I think pretty much lays out what my decisions were in this case and the findings that I had found. As far as the actual discriminatory statements that Attorney Neal says happened, there wasn't anything in the record to suggest that. There were some recordings that were provided to provide evidence of those things. When those recordings were listened to in full by me, there was no indication that any of those statements had been made. While it is true that the respondent did say, she did inquire about whether or not Ms. Dearborn, or excuse me, Ms. Taylor could potentially get help with housing through like disability services and things of that nature. It was simply just a request. There was nothing suggesting that she should live there or that she even could live there. It was simply an ask. As far as the retaliation claim goes, that's come up a little bit. That retaliation claim, again, as stated in the report, it is true that the statement was included in that final election notice, and the MHRA complaint was included in that final notice. There was nothing to show that had that claim not been filed, she would not have been evicted. The eviction process the eviction started well before. Everybody knew that it needed to happen with the repairs, and given all the options that were available to the respondent to provide the complainant with, none of the options that were available seemed like they worked for the complainant, and then everything that the respondent could possibly do to rehouse Ms. Taylor seemed to have been done. And based on all that information, I made findings that I had, or that I did.
Any questions? Commissioner questions for Investigator Leva? Commissioner David.
So it's in footnote 4, you say that the complainant cannot carry her burden of showing that she would not have been evicted had she not filed her complaint, and that's your understanding of the legal standard. Nobody's defending the fact that she made that inappropriate comment about the filing, but you're saying that has to be shown to be if that hadn't been there, she'd still be in the apartment, right?
Correct. That was my understanding of the law, the way it's written, and the way I interpreted it.
Another question for Investigator Leva? Seeing none, thank you, Newper. We've heard from the parties and the investigator. At this time, we are looking for a motion. There are 2 proposed findings. Commissioner O'Brien.
I would take them together, that there are no reasonable grounds to believe that Patricia Dearborn and or TNS Property Management discriminated against Bobby Taylor based on her disability and or sexual orientation or gender identity, and there are no reasonable grounds to believe that Patricia Dearborn and or TNS Property Management retaliated against Bobby Taylor for engaging in MHR, a protected activity, and the complaint should be dismissed.
Moved, is there a second?
Second.
Moved and seconded, any discussion? Sure, David.
Yeah, I'm gonna support the motion and move that there's no reasonable grounds. Obviously, the statement about the filing with the commission is troubling and inappropriate, but I think that is the history here that they've been working over a long period of time to try to deal with this situation. It suggests that that's not that the eviction is not based on that inappropriate comment about having filed the case. I'm a little troubled by the allegation by complainant that the treatment is paternalistic. It seems as though there's a history of this landlord trying to work and accommodate a difficult situation. So I'm not finding that there's discrimination.
Any other discussion? Seeing none, the motion is to find no reasonable grounds on both recommendations. If you are in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Findings are no reasonable grounds. We appreciate everyone's participation. The commission will send a letter to the parties and the council confirming the results of the hearing.
Thank you.
So the next case is, sorry, let me get back to that. Beginning here. This is all Alton Hood versus Chase Apartments et al. H23-0365. The recommendation is that we find no reasonable grounds on both counts, and therefore we would hear from complainant first. And that would be Alton Hood or counsel.
Is there anybody here for Alton Hood?
Good morning. This is Attorney Ted Smith. I'm on the matter for the defendant, Mary Ann Chassie.
Yes, we've got you pinned, Attorney Smith. I'm looking, I believe, for Attorney Pontoon.
Where's the lady out there earlier?
All right, Attorney Pontoon?
Yes.
Am I pronouncing your name correctly?
Yes,
Okay, great.
correct.
You have 10 minutes. Do you want to reserve any of your time?
Yes, I don't think I'll need I'll probably reserve 1 minute. So if anybody's got a clock,
I have one.
that would
here.
be great.
All right, go ahead whenever you're ready.
Good morning. My name is Elizabeth Fontoon. I represent the claimant and tenant in this case, Mr. Alton Hood. Mr. Alton Hood is a person with disabilities. His disabilities are complex. He has suffered several traumatic brain injuries. He also has mental illness on top of that. He also has alcoholism on top of that. This is a case involving a tenancy, and the Maine Human Rights Act makes it unlawful to discriminate against any individual because of disability in the price, terms, conditions, or privileges of the sale, rental, or lease, or any housing accommodations. Here in this case, what developed over time is that there was an unwritten condition to Mr. Hood's lease under which he worked for the landlord for free. And we're talking about 30 to 35 hours of heavy labor for free. And this went on for many years, and it continued. And she would come and she would beat her horn at his door, and he would have to come out. And he knew that if he refused, she would either increase his rent or just decide to evict him. What ended up happening is on August 10th of last year, he said no. He said no to his landlord's son, who had come to pick him up without warning to do the job. He said no. The landlord's son insulted him, called him an effing retard. He then went into the house where he was working and closed the door, wisely removing himself from the situation. At that point, Mr. Lyle Chassie barged into the house, trespassed, he was not invited either, yelled, "There's no one here to protect you," and proceeded to call Mr. Hood an effing retard again, push his head down hard, and tell him that his rent was going to go up. Now, when I go to the website for the Maine Human Rights Commission, there is a brochure titled Unlawful Housing Harassment. The Maine Human Rights Act makes it unlawful to discriminate in the terms, conditions, or privileges of the rental of any housing on the basis of physical or mental disability. Harassment is a form of unlawful housing discrimination when the following standards are met. The harassment was unwelcome. The harassment was because of the target's protected class. The harassment was so severe or pervasive that it created a hostile or abusive housing environment where housing benefits were explicitly or implicitly conditioned on the tenant engaging in unwelcome behavior. Example, trading rent for sexual favors. Well, here, Mr. Hood, in effect, traded a very small part of his rent for free labor. That's what happened in this case. The brochure continues. If you are physically attacked or threatened, you should call the police immediately. This is what Mr. Hood did after Mr. Chassie assaulted him. The regulations implemented by the Maine Human Rights Commission provide that discrimination also means to subject to harassment, and further defines harassment as an assault within the meaning of the Maine Criminal Code. This was an assault. It was an offensive contact that was unwelcome. And Mr. Hood, the only reason that Mr. Chassie was able to carry this out is because Mr. Hood is vulnerable. Mr. Hood is a person with a disability. Mr. Hood is physically smaller. And so what happened is Mr. Hood alerted the police, filed a report. Mr. Chassie was issued a cease harassment notice. He continued to harass Mr. Hood. We made all of this clear during the conference when we spoke with the investigator, and in her report, there is no mention of this assault. She calls it an altercation. There was no altercation. There was no physical fight between the two. We're talking about the landlord's son pushing his head down and telling him his rent's going to go up. If that is not housing discrimination based on disability, I don't know what is. As far as the rest of it, you will note that we did not place any allegations concerning the condition of the rental premises in our complaint. It was solely predicated on the assault by Mr. Lyle Chassis and the retaliation by Mary Ann Chassis, who did not return his papers after he stopped working for free. She did not return all of his papers. And you have proof of that because she did not return a copy of the current lease, and yet her attorney provided it to the commission later. So on all this basis, and because there was a physical assault, I would submit to the commission that this is harassment that is pervasive and severe enough to constitute unlawful housing discrimination. And Lyle Chassis retaliated by continuing to harass Mr. Hood, even after he contacted the police. Thank you.
About 3.5 minutes left. Back to any questions for Attorney Funchal? Attorney Smith, you can sit down. We'll call you back up when you. Attorney Smith, you have 10 minutes. Do you want to reserve any of your time?
No, I do not. I'll just proceed. Good morning. My name is Attorney Smith. I represent Mary Ann Chassis. She is an 87-year-old widower. In 2022, she lost her husband, Gerald Chassis, who was providing the day-to-day back and forth, driving around, moving around, getting things necessary for the apartment rentals that they had. After she lost her husband, she was no longer able to do the day-to-day or have the day-to-days done. Day-to-day could mean going and getting something she needed at the store. It could mean going and picking up mail, especially a certified mail, because that doesn't get delivered at the house. You have to pick it up the local post office. She, of course, had several other tenants, but she had Mr. Hood, who'd been one of her tenants since about 2019. And I guess, except an initial difficult tenancy where he was being evicted, she began to become fond with Mr. Hood. She sought the eviction through the court process in Madawaska District Court. It was such that he was going to be evicted. He was just asking for more time with his support individuals and counselors. And it just such that it worked out that the time that he was being allowed, she softened the need to remove him. She required that he do the things that he needed to do before the eviction started, which was clean up his apartment and follow the basic rules for living there. And he remained. After about a year and a half, he moved to his present location, which is on Mount Calm Avenue, where he has a home. Again, during that time, they became fond, and Mr. Hood would become what she would call endearingly her legs. She has an ailment such that provides her inability, just cannot walk, cannot move. She needs a walker. And he would do the day-to-days, go into the grocery store if there was something small that was needed, or go into the post office if there was certified mail or things like that, and helped her with these things. He'd also do some weed whacking at the front of her home, which was a small stretch around a roadway. And he'd do a little bit of lawn mowing. Mostly, though, the lawn mowing was at his place and weed whacking was at his place. There was also weed whackers that were purchased and provided to him for those purposes. Lyle Chassis is Mary Ann Chassis's older son. He is not an owner of the apartments. He assists his mom only with some basic day-to-days with what she needs in her home. And there's opportunities that Mr. Hood was working with Mr. Lyle Chassis, and he was working with him for pay, or if not pay, for remuneration in other ways, such as like Cowboys, football, jerseys, things like that, mementos. He was also paid by Mr. Chassis. The payment remuneration between Mary Ann Chassis and Mr. Hood was a $100 rebate in his rental. The important piece to know is that he never would have never worked the hours necessary to be able to have exceeded any of the $100 reduction. The claims that he's working 30, 35 hours, he might have worked like that for Mr. Chassis, Lyle Chassis, but no, not for Mary Ann. She didn't have those type of needs. When there was times that there was trash removal, he was being assisted by Lyle or Mary Ann Chassis, and they'd put it in a trailer and they'd bring it, and his garbage would be part of it, and he wouldn't have to pay for his removal fees. It was all part of the total. The important piece that needs to be considered here is this case, I guess, starts prior to the incident, which Mary Ann Chassis has no connection with, in the home where Lyle is upset that Mr. Hood doesn't want to work or is refusing to work. It starts when Miss Chassis, at the beginning of August, goes and reviews the premises where Mr. Hood's staying and finds it in utter disrepair. It is dirty, it's cluttered. There's a smell of cat urine or pee. There's feces in certain places of the rugs. The rugs are dirty. There's broken windows. And the association that Mary Ann had with Mr. Hood up to that time was a good one. She called him her legs. And she looked at Mr. Hood, and he must have known that she was so crestfallen, so disappointed, and said, "Clean this up. I'll be back in a couple weeks." And that was the interaction that Mary Ann Chassis had with Mr. Hood that scared him, because he was scared about being evicted the first time, didn't want to be evicted this time, and this is what started. So the so-called legitimate grounds for discrimination, they're claiming she failed to return paperwork. She did the same thing to return the paperwork upon the request by Mr. Hood or his attorney that she always did. She went to his location where he lived. She tooted the horn 3 times because she can't get in and out of her car very well, and asked that he'd come and get his things. He never appeared, never responded. As soon as somebody came to pick up, and I believe it was his attorney, the paperwork, they were provided. There's nothing legitimate for grounds about claiming somebody's failing to provide papers that she was safekeeping. As far as any papers she's saying that she doesn't have, that's a request that can be made at any time. As far as a copy of the lease, the lease has already expired. He's a month to month at this point, a tenant at sufferance, which I think is what's led to the ominous nature of the filing and the claims. The suggestion of the hostile, harassing environment of Lyle Chassis, it has to be separated from this, because that's a different relationship and a different association as Mary Ann Chassis. Mary Ann Chassis didn't tell Lyle to go there. Mary Ann Chassis didn't go with Lyle. There was no involvement by Lyle. Lyle had used Mr. Alton Hood to do work with him many, many times, and he was upset that he wasn't working like he used to. So we'd submit that there are no reasonable, legitimate, discriminatory basis for this claim against Mary Ann Chassis. We have no additional things to add.
Any questions for Respondents' Counsel? Commissioner Douglas.
Yes, Attorney Smith, good morning. I'm just looking
Good morning.
I'm looking at the report on page 4 where the investigator says this comment about complainant being he used the R word, which I'm loath to use here. You know, the report says while the use of the term, the R word might be severe enough to rise to the level of a hostile housing environment. In some situations, the record here does not support complainant's allegation that Sun called complainant that word. And so I'm wondering, let's say that a fact finder at trial did decide that your client's son did use that word. Does that then rise to the level of a hostile housing environment in your view? And if not, why not?
Well, I think I want to make the distinction like I've made on the prior issue regarding the assault. If we would take this question to the extreme, saying Mr. Chassis is not even related to Mary Ann Chassis, there's no question. If you then move to the fact that he has been helping his mom ever since his father's passed with doing the garbage runs for the apartment units, as well as helping Mr. Hood, as there's a little bit more of a connection. If this would have happened, again, with distinctions, in the apartment unit or house where Mr. Hood was living, I think, again, there's a greater inference that, yes, this is an issue. But it didn't happen in the rental home. It happened in another home, I guess unrelated to anything that Mary Ann Chassis owns, and it's by an individual that's not her agent in that sense. He went there to get Mr. Hood to work, or he was going there complaining about Mr. Hood not working with him like he used to. There was a close relationship between these people. After Mr. Hood had performed some services for Lyle, I think it was when he'd moved out of his home and sold his home, he gave Mr. Hood, who was a big Dallas Cowboys football fan, a lot of memorabilia, which is not being acknowledged. It's not like they're strangers. They were good friends. Mr. Lyle Chassis denies that he called him that bad pejorative. He went on to say that because of an association during our hearing with the hearing officer, that he was loath to use that term. He had used it before, but because of associations that his family had, relationships the family had, and how I believe his spouse may be employed or his daughter is employed, that once was in his vocabulary and had been removed long before this bad incident between him and Mr. Hood. So based on all those factors, I think the hearing officer finding that it was not said is supported.
Thank you.
That's responsive.
Yes, that works for me. Thank you.
Commissioner David?
Attorney Smith, I'm confused about the relationship between Lyle and you say he's demanding that the complainant do work for him, not on the mother's property?
That's correct. That is, because there was work that was being performed by Lyle where you'd have Mr. Hood help him. And they were close friends.
That was not on the mother's property.
I don't think it was for that day, not for that day in question. And if I may, to respond further, there's even history that I found where Mr. Hood would be asking Mr. Lyle Chassis for assistance, where they cleaned out a property.
Is this in the record, Mr. Smith? No.
No, this is additional.
Okay, if it's not in the record, we can't discuss it here.
So I had assumed that Lyle was the agent for his mother and was demanding.
No, he's not.
The complainant continued to do the work that he promised to do for the mother for the rent reduction. You're saying that's not the case?
That's the attempt that's being made to be able to suggest a connection so they can bring this complaint. There's work, if I could provide other additional, which we'll probably have to if this moves forward, that'll demonstrate the relationship and the association separate of that with Mr. Hood and Mr. Lyle Chassis. They're trying to make it look like this is a one-time event between these individuals, and it's not.
And you, different question. You said that he moved after a year and a half from the apartment to a house also owned by Ms. Chassis.
That is correct. It was essentially a transfer. What Mary Ann was doing was placing him in a home where he wasn't going to have people nearby. It was essentially his home. He was alone there along with his son. At that point, maybe his son was a minor. Maybe he would have been closer to 18.
Complainant's son.
Correct.
Yeah. And what significance, if any, do you attach to the moving after a year and a half? That's a voluntary reorganization of their tenancy, right?
It is, and the significance is that he had maintained his apartment. The reasons for the eviction to start off the first time was the clutter, the disrepair, the being extremely dirty, and he'd improved such that she moved him into a home. And when she went to do the inspection in early August of 2023 and saw the entire complete disrepair worse than before, it created a circumstance where Mr. Hood, I think, was afraid that the eviction was going to start again. Even though my client never said she was going to be evicting him. She asked that he clean it up and she'd be back in 2 weeks.
And
But it was
that,
obvious on her face.
the clean it up and I'll be back in 2 weeks refers to the new rental that he's in the house, correct?
The present, yes, the present rental.
All right, and does she then evict him from that?
No, this process started. They brought these complaints, which I would say somewhat spurious. She didn't return his paperwork in time.
Is he still a tenant?
Yes.
Thank you.
Any further questions for Attorney Smith? Seeing none, Attorney Fortune, you have 3.5 minutes.
There is no evidence on the record concerning the prior eviction proceeding that was brought by the chassis against Mr. Hood, save for the evidence that we placed on the record, which was that it was for non-payment of rent. Lyle Chassis, who has now been represented not to be an agent of his mother, was nonetheless present during this inspection, for which no documentation has been provided. This inspection that occurred either in July or August, which that was the first time that I had heard of that. Lyle Chassis was there. Lyle Chassis came to pick up Mr. Hood on August 10th, the day of the assault, to come and do landscaping work at Mrs. Chassie's house. That was the plan. Mr. Hood worked for Mrs. Chassie, and he provided testimony about that at the conference, about bringing bags of pellets up the steps of her house, about bringing in her groceries, about doing all of this work that did amount to 30 to 35 hours of work per week. And we've heard about a friendship between the Chassis and Mr. Hood. And you have to understand Mr. Hood's background. He is someone who grew up in and out of foster care. He has mental illness. And part of what he did to rationalize this was to try to create a situation where he believed that the Chassis had his best interests at heart. They didn't. And based on the facts that were presented, and especially based on this assault carried out by Lyle Chassis, I think that there is enough here to find that harassment on the basis of disability occurred. This is a remedial statute. And when you've got a situation where there is a dispute of fact between the complaining party and the opposing party, in the absence of any other evidence presented by the opposing party, I think that you need to give the benefit of the doubt to the claimant. And on that basis, we would ask that the commission finds that there is reasonable grounds to believe that unlawful housing discrimination on the basis of disability occurred in this case.
Any questions for, Attorney Fortune, sorry. Yes, Commissioner David.
Does Lyle have other properties that he's demanding that Mr. Hood, Mr. Hood do work on?
If it's in the record.
If it's in the record, yeah.
No, that is not on the record.
Are you saying that Mr. Hood performed 30 to 35 hours of labor per week or per month?
Maybe it was actually per month. It wasn't per week. It was per month. Yes, it was per month.
Other questions for Attorney Fontoon? Seeing none, thank you very much. Attorney Smith, you have 3 minutes.
I think the background relationship, when you look at this with an eye towards motivation, there's a much stronger leaning and tipping of the scale in favor of the motivation for Mr. Hood not to want to be evicted. It's been evicted before by Mrs. Chassis, didn't like it. It scared him. And that eviction process alleviated with help from his social workers indicating they needed more time to find him another location. And that lasted so long that Mary Ann Chassie softened and said, well, let's see what we can do to make this work. And in fact, they both made it work. At some point, he was relocated to I would suggest was a better rental accommodation. Then we look at the facts that are not dispute. She visited at the time of a lease renewal period and couldn't believe the state of disrepair. Look at it from the background to see the facts that are not disputed. Then the actions by that tenant to not want to be evicted. With that lens and that camera on Mr. Hood and the suggestion that, it's all because of housing harassment or discrimination by Lyle Chassie because he went to a location other than a property owned by Mrs. Chassie and harmed him and called him a derogatory name. And they're trying to tie that to his rental. I think it's a stretch, and that's why we'd submit that there are no reasonable grounds, no legitimate reasonable grounds to demonstrate Mary Ann Chassie's discrimination against Mr. Hood. Some of his conduct, some of his actions, some of his filings seem pretextual. But what is the real factor? What is the real issue going on? That's why taking a step back and seeing what the real pressure point is, it helps to lay out, I guess, the direction that we submit this case should be for a dismissal. Nothing further. Thank you.
Questions for Attorney Smith? Seeing none. Thank you both. We will next hear from Investigator Morse.
Hi there, my name is Angela Morse. I was the investigator assigned to this case. A couple of things I just wanted to highlight that didn't align with the testimony that I received at the Issues and Resolution Conference. The work done by Mr. Hood that was described certainly does not, would not appear to equal 30 to 35 hours of labor a month. It seemed like Lyle Chassie, Marion Chassie, and Mr. Hood were all friends. They did favors for one another. They helped each other out. They had a pretty strong friendship until everything deteriorated. Lyle doesn't drive, so whenever he needed to go into town in connection to his to maintaining his benefits, his public assistance benefits, or for any other reason, that was Ms. Chassie who was bringing him into town. So to me, it really seemed like it was a symbiotic relationship and that the parties were doing favors for one another and helping each other out. I did not get the sense that, I certainly didn't get the sense that respondents were trying to take advantage of complainant. And I did not, because I definitely would have, that would have stuck out in my mind if it seemed like the work was to the tune of 30 to 35 hours per month. It seemed much more sporadic than that. Also, the characterization of the alleged assault sounds a lot more severe during today's presentation than it was described in the conference. I believe it was described by complainant as he was touched in the forehead. And I do think it's important to mention that Mr. Chassie denied touching complainant. I did find him to be credible in that statement. He did admit to swearing at complainant. He denied using the R word. And again, I found him credible in that statement. So I recommend a finding that there was no reasonable grounds to find that complainant was discriminated against because of his disabilities or receipt of public assistance or retaliated against for engaging in protective activity, and certainly welcome any questions.
Commissioner Davis.
Angela, thank you. I think you might have misspoke or I misheard right at the beginning of what you said. I thought you said that Lyle was being driven by Ms. Hood. You mean?
Oh, no, Mr. Hood was being driven to town by
Right.
mainly what was discussed by Marion Chassie, but I wouldn't be surprised
Right, okay.
if Lyle brought him into town too. But it certainly sounded like Ms. Chassie was bringing Mr. Hood into town several times a month.
What a touch. And you stand by the recitation you gave of the alleged assault, the confrontation between Lyle and the complainant as being much more minor than counsel has presented it here.
Yeah, based on the issues and resolution conference, it did not sound as severe as was being described here. You know, I had to make a credibility determination. So
What's the
and
overall-
I also don't believe that even if an assault did occur, a touching did occur, a pushing of the forehead did occur, I don't believe that was motivated by discrimination based on Mr. Hood's disabilities. I believe that altercation. Yeah.
That's the issue as to whether there's it's on the basis of his disabilities.
Yeah.
And that's what you're finding was not there, correct?
Yeah, here it seemed like there was a friendship that went south.
That went bad.
That soured. And again, I think Ms. Chassie and Mr. Chassie recognized that complainant had disabilities, and they did try to help him out. I think it's important to note also that all the parties in this matter are disabled. So it seems like they tried to help each other out in ways that they could.
What's the overall history of the relationship? How far back does it go in terms of?
I'd have to.
Yeah.
Yeah, I'm trying to remember when he first. So it was a 5-year friendship.
5 years. Okay, thank you.
Yep. And again, they had Mr. Hood called Ms. Chassie mom. Mr. Chassie and Mr. Hood were referred to as the Bobbsey twins, so they were often together.
Thank you.
Any other questions? Yeah, Commissioner Douglas, you're muted right now.
Thank you for the reminder there. I'm trying to keep a low profile here on Zoom.
I appreciate it.
Good morning, Angela. I'm just looking at page 4 of your report, your account of the confrontation, and just so I'm clear, is it a fair characterization to say that you did not find that confrontation, assuming that the son is the respondent's agent, did not create a hostile housing environment? One, because you didn't find the complainant's allegation credible, but also because, and as you say, the record is devoid of evidence of severe or pervasive harassment based on protected class status, right? Is it a fair characterization of your report to say that this incident did not arise to the level of a hostile housing environment because of both of those factors?
Correct. And it also wasn't, in my mind, was not linked to disability or receipt of public assistance.
Okay. Thank you.
It sounded like this was spurred because, there was some bad dynamics in this friendship, and Lyle was upset about how he felt his mom was being treated. So that's why he got upset with Mr. Hood. That's with my read on the situation.
Right. And just so the point I'm trying to make is obvious,
Yeah.
even if you had found, you'd made a credibility determination that, the son had actually made this remark, use the R word, you still would not have found that this situation rose to the level of a hostile housing environment. Is that fair?
No, not based on that one incident. And even if that word was used, I think it would be more just as a derogatory utterance, not necessarily trying to discriminate against a complainant based on his disabilities.
Okay. Thank you.
Any other questions for Investigator Morse? Thank you, Angela. We've heard from the parties and the investigator. At this time, we'd be looking for a motion. There are 2 proposed findings. Commissioner David.
I'll move that we take them together and that we find that there's no reasonable grounds to believe that respondent discriminated on the basis of disability or received public assistance, and no reasonable grounds to believe that there was retaliation in violation of the Maine Human Rights Act, and complaints should be dismissed.
I'd second it.
Moved and seconded. Any discussion?
Yeah, I think we got to it at the end that this is a 5-year friendship. It goes bad because of her husband dying and the work not being done and shared the way it was, but it's not discrimination that's severe and pervasive in terms of housing discrimination on the basis of complainant's disability. And it certainly seems like the judgments of the investigator in terms of her judgments of credibility are backed up by the matrix of the facts.
Any other discussion? Seeing none, the motion is to find no reasonable grounds. If you're in agreement, you'll vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Findings are no reasonable grounds. We appreciate everybody's participation, and the commission will send a letter to the parties and council confirming the results of the hearing.
And that concludes the agenda for the cases for hearing. Pursuant to MRSA section 4056E, I move that the commission go into an executive session to consult with counsel regarding pending and contemplated litigation and the legal rights and duties of the commission.
Second.
Any discussion? Seeing none, if you are in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien. Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Now we're gonna do the tech thing, which you would think I would have figured out by now, and yet.
Want me to join?
No. Good. Okay.
So we're in session again,
Yes.
and I would move that we not litigate H 230143. Most Cal Cants versus Tidewater Law.
That we do.
That we do, yes, I'm sorry.
Yep.
We do litigate that case, and that we not litigate Oral versus Cosmo, E2252, and not litigate Willette versus Trinity Evangelical Church, PA 210236.
And approve the.
And that we approve the settlement agreement in Garrett versus the park.
And authorize me to sign.
And authorize you to sign for the commission.
It's post cause, so I okay with that. Thank you.
Second,
Second.
any discussion? Okay, seeing none, if you vote yes, you're in agreement. Commissioner David,
Yes.
Commissioner O'Brien. Yes. Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Hey. Good meeting. See you all next month.
See you in March.